cache un secret envieux. Chaque matin, un nouveau mystère. Mademoiselle vit sans frontières. Des murmures, des contes d'ombre. Elle marche comme un rêve sombre. Tous les jours, un chapitre écrit. Des légendes que le jour nie. Oh, Mademoiselle raconte ta saga. Les histoires que personne ne voit. Dans la nuit, tu dévoileras les secrets cachés sous ta soie. Un sourire garde des énigmes, des mots doux aux limites abîmes. Elle joue avec le quotidien, transformant tout en destin. Les reflets cachent des vérités que personne ne peut interpréter. Dans son regard mystifié, un monde entier à déchiffrer. Mademoiselle raconte ta saga, les histoires que personne ne voit. Dans la nuit, tu dévoileras les secrets cachés sous ta soie.
Hello, hello. Greetings. Come on in, come on in. We are live on the tube. It's the Saga Reveal, and I'm your host, Madem-Oiselle. So, come on in. Let's chat and gab. Remember, this channel is for commentary and entertainment only. So please hit the like button, subscribe for notification, and share with others. So today we are going to finish the Kurk Burrowes case. We're going to find out what happened with the rest of the charges. Let's see. I'm going to share my screen here. Let's go. We are at the recent discovery of fraud in 2024. I'm going to put this on a full screen and even make it easier. So here we are. Plaintiff was unable to discover the fraudulent scheme until 2024, when a legal investigation uncovered direct evidence proving that defendant Smalls, Mama Smalls, Janice Combs, which is Diddy. So this is the Kurk Burrowes versus Janice Smalls and others. In fact, so here, uncovered direct evidence proving that defendant Smalls had in fact received plaintiff's 25% share as early as 1998. So defendant Smalls actively concealed her role by proving false assurance that she had no knowledge of the transfer by failing to disclose a relevant financial. My apologies, I just got distracted with my mic. And corporate document. Let me get this a little closer. Yes, much better. So upon information and belief, defendant Janice and others engaged and additional deceptive acts beyond 2020. So if anybody wants to follow up with this, my past videos, I've had the other parts in there. So here, including omission and material misstatement regarding plaintiff's ownership's right and financial entitlement, thereby exempting the period of which plaintiff could reasonably bring these claims. Equitable tolling due to plaintiff's inability to discover the fraud, so the toll it did that to him. New York law recognized that equitable tolling applies when a plaintiff, despite due diligence, was prevented from discovering the fraudulent conduct. Plaintiff, due to his financial distress, homelessness, lack of resource, was unable to retain a legal counsel or investigate the wrongfully act until 2024. This is all alleged by a Kurk Burrowes, who was basically an investor in the business, allegedly. Defendants' patterns of deception and concealment actively prevented the plaintiff from bringing his claim with the statutory period. So, wow, it's quite the case. Upon information and belief, defendant took affirmative steps. Let me just keep my comments here in case I miss something. All right, so upon information and belief, defendant took affirmative steps to suppress records manipulation, corporate filing, and obscure financial transaction, all of which delayed plaintiff's ability to discover the fraud. Continuing wrong doctrine. Defendant conduct was not a single event, but an ongoing scheme that continued beyond 1996 and as well into 2020, warranting the application of the continuing wrong doctrine. Each year, the plaintiff was denied his rightful 15% share of profit and his 25% ownership stake. Defendant continued their wrongful conduct upon information belief. Defendant knowingly withheld annual financial distribution, continued making misrepresentation, and engaged in further acts to suppress plaintiff's rights, making the fraud an ongoing violation. What else? Defendant's bad faith and delay tactic. In 2019, Diana Ross's VIP event, Sean Combs and Janice Smalls admitted wrongdoing, claiming they needed to make things right. However, this was yet another delay tactic designed to prevent plaintiff from taking legal action. So that's 2019. Upon information and belief, defendants deliberately misled the plaintiff with false assurance of eventual restitution, luring him into inaction while they continued profiting from his stolen ownership interests. Precedent for tolling based on fraudulent concealment. New York courts have held a fraudulent concealment tolls the statute of limitation when a defendant's deceptions prevents the plaintiff from discovering their claim. See Simkowski versus Saeli, 44, New York, and so on. Holding that a defendant's active concealment of wrongdoing justifies tolling, where a judiciary relationship exists A heightened duty of disclosure is imposed, and concealment by a fiduciary the limitation period. Toll the limitation period. See Maynard versus Salmon, 1928. Finding that fiduciaries own the highest duty of loyalty and full disclosure. That's what the case was about. So plaintiff could not take legal action sooner due to defendant Smalls actively concealment. Active fraudulent concealment. Defendant Janice Smalls cannot assert a laches or statute of limitation defense because she actively engaged in fraudulent concealment to prevent plaintiff from discovering the wrongful deprivation of his 25% ownership interest in BBE and his 15% share of BBE's annual earning. Under New York law, when a defendant intentionally conceals a cause of action, the statute of limitation is tolled until the plaintiff discovers. Wow, so it piles up until they discovers or reasonably should have discovered the fraud. See Szymanski and versus Sally, 1978. For decades, defendant Smalls, Janice Smalls, Mama Diddy, deliberately misled plaintiff by making false statement and omission designed to obscure her role in the fraudulent misappropriation of his equity stake. The following action illustrates how plaintiff was prevented from discovering the fraud until 2024. Well, 2024. Defendant Smalls affirmatively denied any involvement in the wrongful stock transfer. Each time plaintiff questioned her about his missing 25% ownership, she lied, claiming she had no knowledge of the transfer and had never received his share. Defendant Smalls repeatedly blamed others to deflect responsibility. She shifted blame to Sean Combs and Kenneth Miselalis, Esquire lawyer. Falsely portrayed herself as a bystander rather than direct beneficiary of the fraudulent transfer we saw earlier in my videos. So defendant Smalls exploited trust to delay legal action. Plaintiff and defendant Smalls shared a long-standing relationship, standing professional and personal relationship, which plaintiff even serving as the godfather of Sean Combs' firstborn child. Plaintiff reasonably relied on her statement and had no reason to believe she would intentionally deceive him for decades. Well, she did, seems like. In 1919, allegedly, defendant Smalls falsely assured plaintiff that she and Sean Combs would make things right. My apologies. At Diana Ross's VIP event, defendant Smalls reaffirmed prior false assurance, misleading plaintiff into believing that restitution was forthcoming. Hey, restitution is here. I guess the law has to do it. This was a deliberate strategy to prevent plaintiff Kurk Burrowes from pursuing legal action. Well, yeah. As recently as 2020, defendant Smalls engaged in further deception. Yeah, that was 2019, right? She solicited plaintiff Kurk's assistance in developing a BBE documentary, false promising him compensation. The This further delayed all legal action as plaintiff reasonably believed he would be included in the project and financially compensated. It was only in 2024 when newly uncovered documents and legal investigation revealed that defendant Smalls had secretly received and retained plaintiff's 25% ownership interest as early as 1998. The plaintiff was able to fully discover the extent of the fraud. Defendant Smalls actively concealed the fraud to obscure plaintiff claims. So here's another one. The doctrine of fraud concealed applies where a defendant takes active steps to prevent a plaintiff from discovering their claims. See Kaufman versus Cohen, 2003. Defendant Smalls engaged in multiple acts of concealment, including withholding corporate records. Oh yeah, we saw that earlier. Providing false assurance to lull plaintiff into inaction by delaying his claim so he can get any legal. Suppressing financial discovery. We're going to skip this because there's a lot here to still go through. Leveraging plaintiff's trust and economic disadvantage. These actions amount to fraudulent concealment, and as a result, the statute of limitation was told until 2024 when he discovered it, when plaintiff finally obtained the definitive evidence of defendant Smalls' fraudulent act. So the continuing wrong doctrine applies. Even if the fraudulent misappropriation began in 1998, defendant Smalls' ongoing misconduct meant that plaintiff's claim remained timely under the continuing wrong doctrine. See another case here. The fraud was not a one-time event. It was an ongoing scheme that continued years after years, including each year that defendant Smalls failed to pay the plaintiff his 15% profit share. She engaged in a new wrongful act, keeping the claim timely. So since 96, was it 90? Let's go up here for a sec here. 98. All right. Number 2, each time she misrepresented her role in the fraudulent transfer, she renewed the deception. We're going to add that, double it. Deception, further delaying the plaintiff's ability to uncover the truth. Each financial benefits defendant Smalls received from plaintiff's ownership stake continue a new instance of injustice enrichment, extending the claim's liability. This is very interesting. I can't wait to see this one. So the continuing wrongful doctrine applies when a defendant engaged in a continuous course of fraudulent and wrongful conduct. Here, defendant Smalls' Mama Diddy benefited allegedly from Kurk Burrowes' plaintiff's misappropriated stake every year, making the fraud an ongoing harm rather than a single past event. And judgment day is coming. Defendant Smalls' failure allegedly to disclose the material fact combined with her role as a plaintiff's business partner further justify tolling. And that's why I call that video, and I put that picture, business and pleasure do not mix. Alrighty, what do we have here? Defendant Smalls' failure to disclose material fact, combined with her role as a plaintiff's business partner, further justifies tolling here below, wherefore plaintiff demands judgment against the defendant as follows. For compensatory damage in an amount sufficient to fully compensate plaintiff for the loss of his 25% ownership interest in BBE, lost profits, and other financial harm. Additionally, B, plaintiff was independent audit of BBE's earning from inception. I think. Additionally, plaintiff was an independent audit of BBE earning from inception to present day. Compensate plaintiff his 15% share of his early profit compounded over time by 9% interest on top of that. He wants. You go, buddy. I would do. For punitive damage in the amount that we determine at trial sufficient to punish defendant Smalls for her malicious and intentional conduct and to deter such wrongful act in the future. For prejudgment, he says D, and post-judgment interest on all monetary damage awarded as permitted by law. E, for an equitable accounting of all profits, assets, and benefits derived by defendant Smalls from the fraudulent concealment and wrongful transfer of plaintiff's ownership interest. F, for an award of cost reasonable attorney fee and other expenses incurred by bringing this action. G, for the imposition of a constructive trust over any assets or profits obtained by defendant Smalls as a result of her fraudulent conduct, and for such other and further relief as the court deems just, equitable, and proper. That's a nice ending for him. Second cause of action against Janice Smalls. He said there's fraud. Plaintiff incorporates by reference all preceding paragraph as in fully set for in. Oh, let's read these ones. Defendant Janice Smalls willfully and knowingly engaged in an orchestrated campaign of deception, consistently making false representation and deliberately omitting material facts regarding her direct involvement and substantial financial gain from the fraudulent scheme that resulted in plaintiff's forced relinquishment of his 25% ownership interest in BBE. Remember, you got threatened there in the office with some baseball bat and Mr. Esquire. We're going to find it down here. Plaintiff claims are timely under this law, which provides for fraud claim to be filed within 2 years of discovery. Defendant Smalls systematically concealed critical evidence and engaged in deliberate misrepresentation, ensuring that plaintiff remained unaware of the fraudulent transfer of his 25% ownership stake until legal counsel uncovered irrefutable proof in 2024. Defendant Smalls' mama, Diddy, deceptive tactic, and ongoing suppression of material fact ensure that prior lawsuits did not directly implicate her, as she had meticulously hidden her involvement for over 2 decades, 20 years. You go, mama. Let's see how you get out of this one. It's allegedly. Defendant Smalls misrepresented her knowledge and direct participation in the coercion orchestrated by Sean Combs and Kenneth Miscellaneous, Esquire, the lawyer guide. Despite being an active conspirator who directly benefited from the fraudulent scheme, defendant Smalls repeatedly and intentionally engaged in fraudulent misrepresentation and material omission, including but not limited to falsely asserting that she had no knowledge or involvement in the scheme that led to plaintiff being forcibly stripped of his 25% ownership stake in BBE, publicly and privately portraying herself as a neutral party while actively facilitating her and profiting from the fraudulent transfer of plaintiff's transfer to herself. Number 3, knowingly concealing her continued financial enrichment and corporate control over the assets derived from plaintiff's rightful ownership interest. Number 2, defendant Smalls deliberately engaged in this fraudulent scheme to mislead plaintiff, lull him into inaction, and prevent him from initiating legal recourses that could have exposed her role in misappropriating of his ownership. It was too far gone. 10 years, 15 years, that was it. She was gone. At all relevant times, defendant Smalls, Mama Diddy, was fully aware that her representation were false. She knowingly withheld material information, destroyed or concealed records that would have exposed her involvement, and intentionally misled plaintiff and third party to maintain control over the stolen equity. Plaintiff's fraud claims are timely under New York law, as defendant Smalls intentionally misrepresented her role in the fraudulent transfer and actively suppressed material evidence, including her receipt and retention of plaintiff's 25% ownership stake, preventing him from discovering the truth until 2024. And that was his lucky year. Plaintiff's discovery, which is Kurk Burrowes, of the fraud in 2024 within 2 years statutory window, was the direct result of a legal counsel uncovering documentary evidence that proved defendant Smalls' integral role in the coerced and unlawful transfer of his shares. Prior to this discovery, Smalls extensively and deliberately covered up, precluded plaintiffs from challenging the fraud or seeking redress through the courts. Plaintiff justifiably relied on defendant Smalls' false misrepresentations and omissions based on their long-standing personal and professional relationship, the trust he placed in her as a business partner, and her repeated assertion that she had no involvement in the fraudulent scheme. Plaintiff reliance was reasonable and justified as evidenced by the extensive professional and personal trust placed in defendant Smalls. Believed she had an ally rather than a co-conspirator. Defendant Smalls persisted in calculated reassurances that she was uninvolved in the fraudulent stock transfer despite benefiting from it. The absence of immediate access to documentation or internal record implication, defendant Smalls, which she had actively concealed and suppressed. Plaintiff reliance on defendant Smalls' Mama Diddy intentional fraud and deception resulted in catastrophic and irreparable harm, including but not limited to 1. Again, the unlawful deprivation of his 25% share of the BBE ownership, valued at of $10 million based on the label, continued success, and extensive revenue generation. The loss of his 15% contractual equitable stake in the gross earning of cumulative profit of BBE from its inception to the present, leading to immeasurable financial damage. Wow, severe economic hardship, including lost profits, unpaid earning, and the obliteration of wealth building opportunity that were rightfully his. Professional ruin and irreparable reputation harm, as defendant Smalls' Mama Diddy allegedly fraudulent action contribute to plaintiffs' exclusions from lucrative businesses opportunities within the entertainment business. Extreme financial distress had led to homeless and an inability to establish financial stability after being defrauded of his ownership interests. Profound emotional and psychological trauma resulting from the calculated betrayal by defendant Smalls, whose action decimated plaintiff's career, financial well-being, and professional legacy. Defendant Smalls' Mama Diddy fraudulent conduct was intentional, egregious, and calculated to strip plaintiff of his wealth, position, financial security. Courts have constantly held that fraudulently depriving a business partner of an agreed-upon equity interest constitute actionable fraud. See Veritas Capital Management v. Campbell, holding that concealment of financial interests and fraudulent misrepresentation related to business ownership are actionable under New York law. As plaintiff in Kaufman v. Cohen, 2003, fraudulent misrepresentations and omissions that induce detrimental reliance create a direct cause of action for fraud. Defendant Smalls' repeated misrepresentation directly influenced plaintiff's inability to take legal action until 2024, satisfying the element of fraudulent concealment. As a direct and proximate result of defendant Smalls' fraudulent misrepresentation, concealment, and deliberate malfeasance, plaintiff has suffered extensive damage in an amount that to be determined at trial. Plaintiffs seek full restitution, compensatory damage for lost earning, and punitive damage to deter similar fraudulent conduct in the future. So wherefore, plaintiff demands judgment against defendant as follows. So here we go again. It's going to be all repeated for each one. So there's another third cause of action, unjust enrichment, that's going to be here, right? And they're explaining that and using all the information. And this is what the defendants want. Again, for that as well. For the interest, the loss to profit, compounded interest, wow, and so on and so on. Yeah, another fourth cause of action, deceptive business practice against the law, against Janice Smalls and the Doe's defendant. Here we go. Let's enter this. I'm going to skip this because it's very, very repetitive after a while. Fifth cause of action, conversions against her. All of these paragraphs for the ownership. Psychological damage. Sixth cause of action, civil conspiracy. Oh, yeah, that was quite the conspiracy going on in here. So knowingly drafting fraudulent document that misrepresented ownership transfer, providing legal cover for coercion transaction conducted under duress, concealing plaintiff rights stake from corporate filing and regulatory bodies, mama, duty of loyalty and avoidance of conflict of interest. All of these law rules. Let's keep at it. I think we can probably finish this today, and all the compensatory damages that he wants for these are back again. So, prayer for relief. Let's get this one here. Yeah, same thing here. Let's see. Yeah. Yeah, I guess that's pretty much it. Preservation, the term you here. Okay, yeah, I guess that was it. But okay, we'll read this and finish it up. So, prayer for relief. Plaintiff demands judgment against defendant Janice Smalls, lawyer Doe 1, James Doe 1, and other co-conspirators as follows. 8. For compensatory damage in an amount sufficient to fully compensate plaintiff for all financial losses, including but not limited to the value of plaintiff's 25% ownership interest, as well as his 15% stake in gross earning and profit of BBE from inception to present day. Its appraised market value, lost profit, and the harm caused to plaintiffs' professional reputation and opportunity to be added. B. For punitive damages in the amount to be determined at trial sufficient to punitive defendants for their unintentional, malicious, and egregious conduct to deter other from engaging in the similar wrongful act in the future. Kurk will be using your case too. I don't know if you're going to get called, but let's see if you get called as a witness for an order declaring defendant Smalls jolting and severely liable for the harm caused by their wrongful action, including fraud, conversion, breach of fiduciary duty, and civil conspiracy. Right? For an equitable accounting of all profits, revenue, and financial benefits derived by defendants from plaintiff's ownership interest, labor, and contribution to BBE, with a mandate to provide full transparency and disclosure of all relevant record. For the imposition of a constructive trust over all assets, profit, revenue, and property derived from plaintiff's ownership interest and contribution, ensuring that defendants do not remain the benefits of their wrongful conduct. Do not retain the benefit of their wrongful conduct. Sorry. F. For injunctive relief, preventing defendant from engaging in further wrongful act, including the misappropriation of plaintiff's contribution, exploitation of plaintiff's ownership interest, or use of plaintiff's intellectual property and work product. I hope you put your bug on everything. This guy seems to probably know what he is product for sure. G, for pre-judgment and post-judgment interest on all mandatory damage awarded as permitted by law to ensure plaintiff is fully compensated for the time value of his losses. H, for an award of reasonable attorney fees, costs, and other litigation expenses incurred by prosecuting this action to the fullest extent permitted by the law or equity. I, for declaratory relief affirming plaintiff's right claim to compensation, restitution, and restoration of his ownership interest in BBE, and confirming defendant's liability for their wrongful act. For restitutionary damage in an amount sufficient to compensate plaintiff for the full value of his 25% ownership interest in BBE, including any interest of profits derived therefrom, or in the alternative, its current appraised value. For an order requiring defendants to produce and disclose all financial records, communications, and agreement related to plaintiff's ownership interests and contribution to BBE to ensure transparency and accountability. For an order enjoining defendants from any further fraudulent, conspiratorial, or wrongful actions involving plaintiff's property, contributions, or professional reputation, and M, for such other and further relief as the court deemed just, equitable, and proper, including any relief necessary to restore plaintiff to his rightful position and address the harm caused by defendant's unlawful conduct. And it was filed this year, February 25th. So we'll keep an eye on that one. We're done with Kurk. Now, let's see. Let's go have some fun. Stop sharing. All right, let's go check on X and see. Got something interesting. Yeah, we got a new premier in Canada. And yes, of course, his name is Mark Carney, who won the election. Mark Carney today had his meeting with Donald. So, Donald has caused quite a commotion in this country. I want to talk about election interference. That was wrong, sir. Like right now, I'm putting you on a timeout list here. I'm watching you from my side eye. Okay? Because you've been causing a little bit of commotion. And then you confused everybody. I knew when you were doing something and thought maybe, people are supposed to understand, maybe do the opposite. But somehow, no, you got your guy in. You got your guy in, really? Your guy. Come on, Donald. But anyways, hopefully he seems to be wanting to do some things that are a little bit better to keep our relations tight. You talk like we're buddies here. I'm not your buddy for today, okay? I'm telling you clear some of my thoughts here. Yeah. Let's see. What do we have with Carney? Mark Carney. Mark Carney. This was today's. Let's go share the screen here. We're going on X here and check what's going on X. We got some drama. Share the screen. Yeah, Donald, like, really? So you got your guy in. You're telling us you got your guy. Really? I'm paying attention to what you're saying. But it's not your guy. It should be your guy. We should have been our guy. Right? Oh, hold on. Let me make sure the sound is working.
And this will take some time and some discussions, and that's why we're here.
Well, we don't do much business with Canada from our standpoint.
Respectfully, Canadians' view on this is not going to change on the 51st day. Secondly, we are the largest client of the United States in the totality of all the goods. So we are the largest client in the United States. We have a tremendous auto
True, Donald.
between the two of us, and the changes we've made have been helpful. 50% of a car that comes from Canada is American. That's not like anywhere else in the world. And to your question about is there one thing? No, this is a bigger discussion. There are much bigger forces involved, and this will take some time and some discussions, and that's why we're here, to have those discussions, and that is represented by who's sitting around the table.
Well, we don't do much business with Canada from our standpoint.
Respectfully, Canadians' view on this is not going to change on the 51st day. Secondly, we are the largest.
Scared about being the 51 states? Let's see. Well established. We don't do much business with Canada. Canada's a large client of the United States. That's a bit of a fact checking for sure. Really? Let me see this.
They get along very well. They like each other a lot.
Well, if I may, as you know from real estate, there are some places that are never for sale.
That's true.
We're sitting in one right now, Buckingham Palace. You visited as well.
That's true.
And having met with the owners of Canada over the course of the campaign last several months, it's not for sale, won't be for sale ever. But the opportunity is in the partnership and what we can build together. We have done that in the past, and part of that, as the president just said, is with respect to our own security. And my government is committed for a step change in our investment in Canadian security and our partnership. And I'll say this as well, that the president has revitalized international security, revitalized NATO, and us playing our full weight in NATO, and that will be part of it.
And they have.
Oh, yeah. Revitalize. Yeah, let's see. What do you guys NATO want to do? Well. This is Canada, guys. It's smooth diplomatic. What does it say? This is why Canada choose Garvey. A smooth diplomatic matador who can handle the bumbling bull with finesse, while at the same time making it clear Canada is not for sale. Yeah. Oh, Lord, look at that. Both of them sitting right there. Interesting, all these trophies and gold decoration in the back. Listen, send me some gold here, Donald. We're not gonna be 51 state here. I want to be rich. You look like you have too much gold. What else? Carney. Drop 8 to thank Marconi for standing up to Canada. Well, that's your job. You're not standing up, really. Okay. Well. Let's see. Oh, yeah, today was Diddy's case. Oh, boy. I wonder how today's end. Oh, Little Rod. Okay, yes. By the way, I wanted to check this with you guys to keep you posted. Little Rod, sex assault, thanks to Inner City against Sean Diddy Combs, survived, but now they just removed Cuban Gooding Jr. and Justin Combs, his son, from the case, and the judge is letting it in. So they had to, I guess, clear up certain things in the book. So, opinion order, the court joins, filing a letter explaining the statute of service of process as to defendant Cuban Jr. and Justin Combs. See, this is the case I read here a while ago. Previously, the court has granted Jones' request of an extension of time to serve Gooden and Combs, as had set to November 8th. And Jones missed the deadline without effectuating service and requesting additional extension. Jones then moves the court to an alternative service of Gooden and Combs by means of publication in 2 newspapers. In support of the motion, Jones filed April 8 a proposed order, blah, 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 a memorandum of law. So looks like, yes, they have had some changes and they're removing Justin and Cuban Jr. from the case. Oh, sorry, they were delayed. So, yeah, this is to dropping. Service may be made by personal delivery or by any combination of. Let's go read. Yeah, that's all it was. Yeah, they were removing. Survived. Good job. So the judge is continuing with his claim. Here, 2 hours ago, this guy was reporting about this all day. All day. Oh, what happened with these are all the witnesses they agreed on today. Let's see if he posted a video. Get some more material, Celine, and there's Patreon. Let me see. What else? Did he have any video today? No. Looks like. Yeah. He didn't do a video at the end of the day, it looks like. Inner City Press. Let me go see if, what is her name? Infamous Sylvia. Let's see what infamous Sylvia had today going. There she was today at the Diddy trial. Let's go see. Okay, good. She is in my list. Exclusive. Oh, yeah, that was a while ago. No, I don't think she had anything added here since. Yeah, that was since she's on YouTube now. Yeah. Let's see, Diddy's. What's going on with Diddy? If there's any latest thing that we missed. Stop it. The prosecutor on P. Diddy's case have released the attendees of his parties. Kamala Harris is on it, really.
That was dropped by prosecutors. You guys want to see what celebrities and politicians went to the Diddy parties? Well, we're going to show
Very strange. While I was talking, I think I'm gonna have to end the stream. Yes, looks like it. Mhm. Mhm. All right.